The drama continues in the case of Sarah Boone, the accused killer who prosecutors say zipped up her boyfriend in a suitcase while playing hide and seek and left him for dead. It's now been 4 years since then, and Sarah Boone is finally set to go to trial next month. Ahead of that, we're taking a deep dive into her case with the most shocking moments we've seen so far and what to expect ahead. Welcome to Sidebar, presented by Law&Crime. I'm Gillespie. The drama just keeps on coming in the case of Sarah Boone, and the number of attorneys she's gone through has now officially reached double digits. That's right, Sarah Boone is on her 10th attorney that she somehow wooed with a homemade help wanted ad. And now there's possible talk of a plea deal. We'll get into all that, but first we have to head back to February 24th, 2020.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
F you.
This now infamous video was taken by Sarah Boone herself, showing her boyfriend, 42-year-old Jorge Torres, inside a suitcase. She says they were playing hide and seek when Torres hopped inside. Prosecutors say Torres was begging for his life, telling Boone he couldn't breathe. But you decide for yourself.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real or ransom. Might want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you chewing on me.
Sarah. Breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Boone admits that she was drinking, but says she didn't mean to leave Torres inside the suitcase. She says she simply forgot and went upstairs to go to bed. Boone says she later woke up when her phone rang, and that's when she found Torres, who was unresponsive. So naturally, investigators wanted to check this all out, and that starts with a police interview.
So he's got scratch marks to his back.
I know what that's from.
Okay. And it's called a contusion. Do you know what a contusion is? So, like, basically you're getting hit, and then, you get a mark from it. You'll get bruising. Like someone hit you or something like that. It's called a contusion. So he had some injuries to his left shoulder. He had a cut near his lip. We could see his mouth was a little
I haven't laid a
swollen.
hand on him.
Okay.
Also, too, he fell off my son's bike.
Okay.
So I don't know. And he's notorious for running into the wall or the hall tree. So
Okay. What about the scratches? Because
Sex.
there's also sex.
Yes.
The story of Jorge Torres is a difficult one to talk about, but I think it's a really important one to cover. And one of the reasons we're able to do that is because of our sponsors. So I want to highlight one today, Upside. It's a free app that gets you cash back on daily essentials like gas and groceries. Every time I pump my gas, I now use Upside, because why wouldn't I want free cash back? And yes, it's actually real cash back, money that appears in your Upside app that you can then transfer into your bank account. All you have to do is download the Upside app, claim an offer for whatever you're buying on Upside, then pay as usual using credit or debit and follow the steps on the app to get paid. To find out how much you could earn, click the link in the description to download Upside or scan the QR code on the screen and use our promo code Sidebar to get an extra 25 cents back on every gallon on your first tank of gas. During this interview, Boone casually mentions that Torres was allegedly abusive before his death. This idea has come up even as recently as this week, but here's what she said back in 2020.
So what do you mean by he comes after you? Like,
He gets belligerently drunk.
mhm.
Like, I don't know if you all have looked through my phone yet and seen any of the pictures and the videos that I have taken.
Mhm.
And at one point, I started documenting everything.
Okay.
So you all will see in my pictures bloody fingers, split foreheads. He split my nose. I've got this.
Right.
I don't know if Brian told you about it, where I had to have I had one really bad surgery, but then it got really, 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 really bad, where I had to go like 4 or 5 more times afterwards for them to tend to it, from him poking me in the back of the leg.
Right.
So it's,
Then why are you still with him?
everybody asks me that. When I tell you guys this, I really love him, like I do, and I feel like I can help him. Like, I feel like I could help him, which I did, because he came a really long way.
So investigators point the discussion towards Torres's death and the suitcase.
My intention was not to leave him in there. Please understand that. My intention was not to leave him in there.
But you went upstairs thinking that he could get himself
Yes.
out, but the video shows
That's
at
what I
no
told
point
you.
can I see his fingers. And
He'll
it
be up
looks
here any
like-
minute.
And then 30 minutes later, he didn't show.
And he's telling you
And I
he
didn't
can't
wake
breathe.
up.
Do you
He's
think
not
he's
able to get
joking?
out.
You told me he was laughing, and
We were
the
before.
video, there's no
When we
laughing.
first got in there, both of us were.
So how long was he in there for? Like, this video is at 11:12 when it starts, so was he in there for like a long time prior to you recording this?
No. No.
So it goes from funny to no longer funny,
But
and
I
you're the
didn't,
only one laughing.
but I didn't think that he was, like, panicky. Like,
So pushing up on a suitcase saying, Sarah, 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 I can't breathe.
George has done that in the past before, too, where it's just like he thinks that he's woe is me kind of thing, where it's like, I don't
He's
think,
never been locked in a suitcase, that's
No.
where he couldn't get out, so.
it's kind of, I thought it was
And
the
you know
boy
the oxygen
crying
is
wolf,
something.
crying wolf kind of thing.
Okay.
And again, my plan.
But nowhere in there is he laughing, is he joking, he is begging. And you're the only one laughing,
Okay.
and you're the only one saying derogatory comments, like you're mad.
We showed you that video before with these alleged derogatory comments. It's both hard to watch and hard to forget.
I can't breathe, babe.
Oh. That's what I feel like when you chewing on me.
Sarah! Please, Sarah!
So Sarah Boone is eventually charged with second-degree murder in Jorge Torres' death and has been held in the Orange County Jail in Florida ever since. And along the way, there have been many delays in Boone's trial and a few different attorneys. Here's how the math breaks down. At this point, Boone has had 8 court-appointed attorneys and 1 private attorney. For those following along with some fast math, that brings her current attorney, James Owens, to number 10. But we can't forget that during this mix, Boone also had a stint where she represented herself. This happened earlier in the summer, and we actually reported on it here on Law&Crime. All this was discussed in open court.
So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the the Ferretti hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file.
Okay, we have to pause really quick to remind you of the dozens of jailhouse letters Sarah Boone has written since her arrest. Basically, she used the letters to complain about her attorneys, request new counsel, or petition the judge. Here's just a taste. On May 15th, 2023, she wrote, quote, "My truth needs to be heard and it is my right. Do not give me rights expecting me not to fully utilize them. I voted for the president and governor while here in jail, and stop violating what I've been trying to utilize or less the value of my capabilities and opportunities. I'm not apologetic in any way for being an observant, hardworking, above average, non-stereotypical inmate. I can only imagine, sadly, how others not as outspoken as myself have been and are being mistreated, overlooked, and dehumanized." Then she writes in all caps, "Get it together." She continues, quote, "You've told me in part when I've tried to voice my legitimate concerns to you in the courtroom, 5 times total in 3.3 years, and in my letters to, quote, save it for my next attorney, if told anything at all. Do tell your honor, which attorney?" So back to the hearing from August 5th of this year, the judge promises he's read every single letter.
I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order. You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
At that point, the judge is telling Boone her request for standby counsel is denied. So basically, she has to go it alone when it comes time for trial. This is during Sarah Boone's pro se era, when she's repping herself, and we actually saw a bit of this when she questioned a witness.
First off, in your, in quotes, research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor?
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Okay.
I am prepared to give her the dates. Okay. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in court?
At the jail, yes.
Who is your contact, please? I've never missed a date.
This is a database that I got this information from.
So for a while, we thought that Boone was on her own. We even talked about it last week on Sidebar, when Boone herself filed a motion to dismiss. When I opened the motion, I didn't expect to open a history textbook. She literally has the Bill of Rights. Yeah. She's talking about, she has the second one, talking about the militia, the right to bear arms, obviously irrelevant in this case. Was that a little unconventional to you too, seeing the entire Bill of Rights right there?
You know, when I saw this motion, I just immediately went into lawyer mode. I wanted to see case law. I wanted to see a legal argument. I want to see a summary, a history, so that I can shepherdize and be prepared. But when I saw it was just a copy of the Bill of Rights, I'm like, no, this is not good. There has to be something on the third page. Yeah, it was a copy of the envelope that she mailed to the court.
But jump to this week, and suddenly she's got a new attorney. That's this guy, James Owens, and he's shaking things up. This half of the story is almost too crazy to believe. Remember this handmade help wanted ad that Sarah Boone made a few weeks back? Our very own Elizabeth Milner actually reported on it when it came out. Sarah Boone drew it up herself, writing across the top, "Inmate seeks attorney." Looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. A list of required qualifications includes client inclusion at all times, extreme efficiency in listening, communicating, understanding, and maintaining faith in the client. At the very bottom, she wrote, "Invest in the oppressed, believe." So apparently Owens saw this ad, and that's how he ended up working with Boone. And he really jumped right in. At a hearing just this week, Owens made some new motions, trying to correct a few of the requests Boone had made when she was pro se.
Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Deininger, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
Owens says he doesn't have all the discovery. The trial date is just around the corner and the clock is ticking. So is the state gatekeeping? It doesn't really seem like it.
I've spoken with Dr. Berkland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berkland. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB, and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one, and this morning we'll get that done.
Putting discovery aside, let's move on to the angle the defense is going to take. Owens showed his hand a bit here, referencing battered woman syndrome. That's referred to by multiple names here, including battered wife syndrome or battered spouse syndrome.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still have to peel back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was almost ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim to. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance.
Now, Owens is asking for more time, but the judge takes out his laundry list of receipts to show what he believes was more than enough time for Boone's defense to prepare.
All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours, You were aware of what the order identified, which was in paragraph 6 of the order and adjudged portion, that trial is specially set for October 7th, 2024, and it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton v. State, 220 Southern 3rd 1152 and 1176, Bargo v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JACS is not here to have the opportunity to review those.
And here's the judge's mic drop moment, saying Sarah Boone only has herself to blame for the lack of prep time.
This case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order.
So the hearing wraps up there. Sarah Boone is still scheduled to go to trial on October 7th. But speaking to local media, her new attorney says he discussed the possibility of a plea deal.
There was attempts to try to resolve it. If we would have come to terms, I would have filed a notice of appearance. We would have set it for court, set it for hearing, and the case would have been resolved. So we did make attempts, like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations. That's just part of it. So there were attempts to settle it. I was kind of like a mediator.
It doesn't really sound like a plea deal is going to be agreed upon, at least for the near future. But if there's one thing we can be sure of in Sarah Boone's case, it's that nothing is for sure. Okay, that's all for Sidebar today, but make sure to subscribe to us. You know this case is one that Jesse Weber will continue to follow, and you can find all the latest updates by subscribing on Spotify, Apple Podcasts, or anywhere you listen. I'm Gillespie, and this has been Sidebar, presented by Law&Crime.